Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying professional responsibility and I'm studying lawyers' candor to the tribunal and also lawyers' impartiality. Before I go into my rules, I would like to introduce this book to you. And I would like to say this is the last time that I'll be introducing this book in my videos because I just realized that once I become an attorney, this is where I'll be looking for my rules. And if I keep on moving it around, bringing it to the pool, showing it in front of the camera, it's going to start to fall apart. And I don't want that to happen. It's already starting to fall apart and I don't like that. So what I'm going to do is I'm going to set this book aside now, maybe show you the inside a little bit. So this is what it looks like. These are my rules, the comments, and everything I need to know. So this is what I'll be reading from. Now I'm going to go ahead and jump right into my notes for you. So in this video, I'll be talking about a lawyer's candor to the tribunal and also the criminal or fraudulent conduct. And finally, I'll be talking about the duration of obligations. So first of all, a lawyer's statement. A lawyer shall not knowingly make false statement of fact, fail to disclose controlling law, or offer false evidence. So actually you get your rule right here. I'm going to bring it real close to the camera for a second. Maybe you can even pause and zoom in so you can really see where I'm getting my rules from. Here, you see that? I circled it right here. So this is actually rule 3.3, candor towards the tribunal. And it starts right here, 3.3a. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So this is the part 1. The part 2 states that fail to disclose to the tribunal legal authority in controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by the opposing counsel. So now the third part. Or offer evidence that the lawyer knows to be false if the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, and the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. And a lawyer may refuse to offer evidence other than the testimony of the defendant in a criminal matter that the lawyer reasonably believes to be false. So that is very important, the reasonably believes to be false part. And now I'm going to move on to the part B. So this part B is actually very important. This has to do with the reasonable remedial measures. So it states that a lawyer who represents a client in an adjudicative proceeding and who knows that a person intends to engage or is engaging or has engaged in a criminal or fraudulent conduct related to the proceeding shall take reasonable remedial measures. So I actually underlined that. I suggest you underline that. That's very important. Including, if necessary, disclosure to the tribunal. So when should the lawyer actually speak up? Because there's a duty of confidentiality. But there's some cases that the lawyer should actually speak up. So this is what we're thinking. This is how we're thinking right now. When does a lawyer have the duty to speak up? And also, the lawyer cannot allow to testify when he knows that someone is knowingly about to commit perjury. And the lawyer cannot offer evidence known to be false. So remember that. He cannot offer evidence known to be false and cannot allow to testify knowingly that they're about to cause perjury. And also there's this thing called as a noisy withdrawal. This is when the lawyer knows that his client is about to do perjury and is about to do fraud, so he'll withdraw from the case. But what happens is that when a lawyer withdraws from the case, this could cause a lot of problem for the client, because now the client is halfway through the case, the lawyer was defending the client, and now he's suddenly withdrawing. So we call that a noisy withdrawal because it's going to cause a lot of problems for the client. And the lawyer must not do that. The lawyer cannot just withdraw from the case. It doesn't work like that. But if the client is really doing criminal acts and the lawyer knows about it, at that point he can do the withdrawal called the noisy withdrawal from the case. And also the next part that I'd like to talk about is the disclosure of confidential information. This is also protected under the Rule 1.6. And also I'd like to talk about the Part D. It says, in an ex parte proceeding, a lawyer shall inform the tribunal of all material known to the lawyer that will enable the tribunal to make an informed decision, whether or not the facts are adverse. So over here, it's very important. What is an ex parte proceeding? Think to yourself. What is an ex parte proceeding? Basically, I looked this up. This is when the lawyer pulls the judge aside and talks to the judge just secretly and in private. And he cannot do that. He cannot just, talk to the judge secretly. He should disclose all the information everywhere. And the ex parte communication, over here I said counsel and court when opposing counsel not present unless authorized by the court. So it must be authorized by the court. So I'm going to move on and repeat what I just told you. So a lawyer shall not knowingly make false statement of fact, fail to disclose controlling law, or offer false evidence. Something here, I took a note for myself because sometimes I'm a little clumsy, I'm not perfect, I make mistakes, and I just wanted to let myself know, take it easy on yourself. Yeah, it's extremely important to cite right, to do everything perfectly, but if you don't have the right page number for a case, that's not material, okay? So you want to look at the materiality of what the lawyer is not disclosing. If the lawyer is just not disclosing and forgot to cite to a page number, that is not material. And the next thing I'd like to talk about is criminal or fraudulent conduct. So over here is the knowledge requirement is important, intends to or is engaging criminal or fraudulent conduct related to the proceeding. So in this case, you get the reasonable remedial measures required when there's knowledge, intends to, or is engaging in criminal or fraudulent conduct related to the proceeding. The next thing I'd like to talk about is duration of the obligation. So over here, you want to look at the conclusion of the proceeding, the final judgment affirmed, and the time for review has passed. So this is the duration of the obligation. So when we have the final judgment, then it's at the end of it. And also, right now I just talked about no false statements or evidence. You must have a correct material misstatement, reasonable remedial measures for false evidence, and must disclose controlling adverse law. And finally, I talked about how the obligation is right till the end of the proceeding. The next thing I'd like to talk about, actually this would have been a whole separate video, but now that I'm going at it, I might as well just make a whole video out of one. So this was supposed to be a video on candor, and now we're talking about impartiality. So the rule is Model Rule of Professional Conduct 3.5. I'm going to show you right here, 3.5. It's on this page. Right here. This is where you find your rule. So, in this rule, it states that a lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by law. So this is actually very simple. A lawyer cannot just go up to the judge or the juror and just convince them to, vote in his favor. It doesn't work like that. That's wrong. The lawyer cannot go bribing the juror, the lawyer cannot go bribing the judge, the lawyer cannot go influencing the judge or the juror or threatening the juror. No, that's wrong. The lawyer cannot make promises to vote politically for the judge. All that is wrong, of course. I'm sure you know that. That's just common sense. But this is what this rule says. Rule 3.5 is impartiality and decorum of tribunal, because even though there are these rules, the lawyers sometimes act in ways that they shouldn't be. They play dirty, so they must go by the rules. Hopefully I'll be the type of attorney who'll go by the rules. I don't plan on playing dirty. This is not my style. I'm going to face everything like a man, and honestly and morally. So that's what lawyers should be. They should be honest and moral, and basically, in other words, sorry for my language, they should not screw each other over, and they should not be bribing and doing all those wrong stuff. And also I just talked about the ex parte communications, which is prohibited with judges, jurors, so they cannot basically go and talk to the judge privately or the juror. So what I suggest is that if you're an attorney and you're in a court and you see like jurors getting in an elevator, just stand back, let them take their elevator, let them do their thing. You don't want the drama. Even though if you got in an elevator with them, there's no rules that say, oh, you cannot get in an elevator with a juror or you cannot see them in the cafeteria. But what I suggest is that right from the beginning, you tell the jurors, hey, you know, don't take this personally. This is my job. I'm trying to do my job. Like, it's best that we don't talk to each other and we just leave it as hi, bye, and all of that. So that's just my suggestion to you. Just be smart and don't be talking to the jurors. Don't be influencing the jurors. That's just not right. And also, the next thing I'll be talking about is no juror contact after a proceeding where prohibited by law or court order, and the jurors say no contact, and also you don't want to harass or misrepresent yourself. Lastly, I'd like to talk about disruptive behavior. So you don't want to have a disruptive behavior in the courtroom. You'll get sanctions, and disruptive behaviors are prohibited. Before I finish up the video, I'd like to read the rule for you. So, Rule 3.5, Impartiality and Decorum of the Tribunal. A lawyer shall not seek to influence a judge, juror, prospective juror, or other officials by means prohibited by law. Communicate ex parte with such a person during the proceeding unless authorized to do so by law or court order. Communicate with the juror or prospective juror after discharge of the jury if the communication is prohibited by law or court order, the juror has made known to the lawyer a desire not to communicate, or the communication involves misrepresentation, coercion, duress, or harassment. Or finally, Part D, engage in conduct intended to disrupt the tribunal. So basically, the part 1 of the comments is that the lawyer can present arguments only. You cannot go hypnotizing your jury. You cannot go play dirty, basically. One of my professors, my professional responsibility professor, he gave this really funny example, which does not happen anymore because lawyers cannot smoke cigars in courtrooms. But he was talking about this lawyer who'd smoke a cigar and just like get one of those electronic cigars that the ash doesn't fall. So he'd be sitting there, leaving that on and basically distracting the juror because now the jury is staring at his cigar, waiting for the ash to fall. So, as a lawyer, you're not supposed to be distracting the jury like that. That is disruptive behavior, although, you know, you cannot prove it. At this point, if you have a cigar in a courtroom, hey, it's obviously disruptive behavior. But, you know, in the past, I think there was a time where people were even smoking cigars in the courtroom. And it happened that there was an attorney who took a machine cigar where the ash wouldn't fall so that the jury keeps staring at it and they get distracted. Because actually, from my experience, I've learned that attorneys are really smart people and they know a little bit about hypnotism and a little bit of magicians, and you know, they're just trying to argue and win. So a lawyer is basically just allowed to argue their case, and that's it, nothing more than that. So that's pretty much everything I was talking about was the candor, and then I also moved on with improper influence, which is not allowed, is prohibited. I talked about ex parte communications, which are prohibited unless allowed by law or court order, and I talked about post proceedings contact with jurors that may be allowed. And that's pretty much everything I wanted to talk about. So in this video, I went through Rule 3.3, Candor towards the Tribunal, and I also went through Rule 3.5, Impartiality. That's pretty much everything I wanted to say. I really hope you enjoy studying, and this is a really good book. Good luck, stay safe, stay healthy, and so I came out here to make the video. As you can see, I'm by the pool. Because of this coronavirus pandemic, the gyms are closed again and everywhere's closing up again, and I really worried that if I don't come out here today, the pool will be closed. So after this, I have my bikini, I'm gonna jump in the pool, go for a swim here with my boyfriend, and I really hope things get better, and I truly hope you stay safe and you stay healthy. Good luck.